with bringing these things under writs and other statutes. And so one of the reasons why, if you go back in time, you can find cases where they're brought as writs and so forth, is because originally, for 10 years, there was no other way to do it. Even after the amendment, a lot of plaintiffs continued to bring these as writs or declaratory judgment actions. And if respondents didn't move to dismiss, as we have here, then the court would go ahead, and you can find cases in which after the amendments this is still occurring, but it's simply because nobody brought a motion such as we have under the plain language of the statute saying this is an adequate remedy of law. But there's no question, when you read the statute, that the theory that you have to bring the option appeal under a declaratory judgment action rather than under this provision, which says this is a way of appealing under this chapter, under SEPA, the underlying action. Now, the second sheet in the stack is the language for the declaratory judgment action. And what I've highlighted here is it says a person interested, and specifically regarding a written contract, may have determined questions of construction or validity. And I'm going to highlight the word may. What the legislature was saying is a declaratory judgment action is available and may be used. But when you read that together with the principle that it can't be used if there's an adequate remedy of law, it's very clear that this is not an exclusive way of bringing a challenge to the lease. It could have and should have been brought under SEPA as a freestanding appeal. Now, if that wasn't clear, if you go to the next sheet, this is an excerpt from the Land Use Petition Act, and the other side relies on a case from the Land Use Petition Act for the proposition that you have to bring the appeal of the underlying action under a statute separate from SEPA. But as this statute says right in the caption and then later on in the text, the Land Use Petition Act is the exclusive means of judicial review of land use decisions. So in contrast to the declaratory judgment action, which had that may language, the permissive language, here it's saying if you're going to challenge a land use action like a county permit, you have to start with a LUPA petition. So in fact, you will find SEPA challenges that are tied together with LUPA. And it's because of this explicit language in the Land Use Petition Act. And so that's where that comes from. And again, to the extent that the plaintiffs rely on Land Use Petition Act cases to say, you see, there has to be an independent claim against the underlying action, the LUPA cases are distinguishable because of this exclusive remedy language. The final sheet in the excerpts I gave you is from the Administrative Procedures Act. And this is another case that's relied on by the plaintiffs to say you have to bring your attack on the underlying action through a statute other than SEPA. But again, if you look at 3405.510, it says this chapter establishes the exclusive means of judicial review of agency action. And there the agency is defined as a state agency. So what you have in this statute is if you're going to challenge a state agency that's taken some action, you have to bring it under the APA. And if you want to, as a part of that challenge, say that they violated SEPA, then you bring your SEPA claim together with that. And so it's very similar to LUPA in that regard. And so again, to the extent that the plaintiffs rely on that case in their response to the motion to dismiss, it's distinguishable. What's really not debatable is as Mr. Schechter said, a constitutional writ is extraordinary. And the case law is very clear that if there's an available remedy at law, that should not be used. And as we've indicated, SEPA provides that freestanding statutory remedy. It's available, and it should have been used. And likewise with the declaratory judgment action, yes, you may use it to challenge a written contract, but you may not use it, and this is black letter law at this point, if there is an adequate remedy at law. And again, SEPA provides that. So just to sum it up, the plaintiffs have conceded that the statutory writ is not available. It's very clear from the statute itself, SEPA, and its legislative history, where the legislature said we're trying to replace these other ways of bringing this appeal with a claim under SEPA of both the underlying action, in this case the option to lease, and any SEPA claim. And for that reason, these claims should be dismissed and the complaint should be dismissed in its entirety. Thank you.
Sarah?
So,
Go ahead.
3 for 5, Your Honor.
You can file.
Let me, on the standing, Your Honor, I've never heard the argument before that if there are multiple permits, that you can't challenge one of them because there's no harm associated with just that one, because they got to get them all. It's not till they get them all, and therefore it's conjectural that they'll get them all. Their land use decisions, government projects, private projects frequently have multiple permits and approvals to obtain, and it's not conjectural that they're going to get them all. And the standing cases provide that if a neighbor is going to be impacted by the project that goes in, whether it's a subdivision or a gravel pit or whatever, and you're close by, you have standing. And it doesn't matter that you are challenging the first of what may be many government permits and approvals that are necessary. By their reasoning, I guess, you wouldn't have standing not only to challenge the first one, you wouldn't have standing to challenge the second or the third or the fourth. You'd only have standing when the last one was being issued, which would just be nonsense. So let me turn to arguments about the writ. And first of all, we did not concede that there was no statutory writ. And in fact, there was a section of our brief that addressed that. I took some umbrage with the claim by the Port, or Adage, I guess it was, that there was a Rule 11 violation for pleading statutory writ. Let me just digress, I guess, for a minute to talk about the distinctions between a constitutional writ and a statutory writ. Constitutional writs are broadly characterized as challenges to legislative action, like a decision to enter into a lease might be viewed as a discretionary legislative decision. A statutory writ is available to challenge quasi-judicial decisions. And sort of the classic example of that, in days gone by at least, was if you had a hearing examiner proceeding at the county level and you wanted to challenge that. Well, it's clearly a quasi-judicial process, and that's where the statutory writ was used. The lease here, I think, if you had to ask me, I think it's more of a constitutional writ because it's a legislative discretionary decision. But there are cases that talk about what constitutes a quasi-judicial decision, and it talks about looking at, is there a specific parcel of land involved? Is there a specific applicant? Is there a pro and a con side that's been readily identified? And those are some of the things the courts look at to determine whether it's quasi-judicial. So we pleaded both, and that's what practitioners do in this area, because they don't want to end up in this kind of a position where, you plead one or two potential grounds, and then respondent says, "Oh, you forgot about this other one." So we plead them both, and if we hadn't, I don't doubt that the court would have claimed we should have. They would have, if we hadn't pled the statutory writ, they would have claimed this was a quasi-judicial proceeding, and that's what we should have pled. So, I'll confess, I did not see the possibility that they would claim that we should have pled a separate cause of action under SEPA. And you know why? Because in 30 years of doing this, I've never seen it done, and there's no court case that has ever said that that's how you have to do it. And counsel can get up here and be very creative with the statutory language, and he could say, well, that's the way it used to be. But you know, the cases I cited weren't from 1973. The cases I cited were 1998, 1999, 2007, 1996. These are recent cases. Modern practice under SEPA has used the writs. The only time you don't use a writ, and it's frankly, I say the only time, I mean it's a large number of the cases, if you have a